come overnight, it just look like this. This shit ain't overnight, been through so much shit in my life. The gun colder than ice, that blade sharp cut you like a knife. Always had my own low fame, let a nigga bone feed me with a slice. We was grinding all night just to make them turnovers precise. I had to sacrifice, I had to cut some ties, minimize. I had to realize, I use my real eyes, see through the lies. Club going live, range guys, say FBI. Notify the guys, I swear they had the nerve, think I was high. This shit ain't overnight, that's a whole lot of flips. This shit ain't overnight, took a whole lot of trips. This shit ain't overnight, gotta learn and get your grip. This shit ain't come overnight, it just look like this. Blood, sweat, and tears, I lost peers to face my fears. Learn to perfect my grip, living on the edge so many years. When you living life in a fast lane, gotta know when to shift the gears. Gotta decode everything I hear in my ears, so severe. This shit ain't overnight, that's a whole lot of flips. This shit ain't overnight, took a whole lot of trips. This shit ain't overnight, gotta learn and get your grip. This shit ain't come overnight, it just look like this.
What's going on? FA show.
When you were younger, did you
No
ever
good
come to
trial.
know an individual by the name of Jeffrey Williams?
Yeah.
How long have you known Jeffrey Williams?
I'm not good with time.
Alex,
Since we was kids,
about how old were you when you first met him?
I can't remember the age. As
Was
far
it,
as I can remember, I knew him.
do you believe it's while you were in elementary school, middle school, or something else?
I've been knew him. I can't.
You can't say when you.
How did y'all meet?
Before I knew him, I knew of him. Put it like that. I knew his family members before I knew him.
Which family members did you know before you knew him?
His mom, his dad, his sisters.
How did you know his mom, his dad, and his sisters?
I can't remember which one of them, but they stayed in my apartments. I don't know if it was his mom and his dad, but they stayed in my apartment. I just never seen him. I always seen his brothers and sisters.
And did they stay in your apartments at Gilbert Gardens?
Yeah.
And since you first saw his family before you met him, did you have any type of relationship with his family members?
No, we was kids. It was just at the basketball court. You know?
Now, do you call him Jeffrey Williams?
Huh?
Do you call him Jeffrey Williams? When you refer to him, do you
I don't call nobody by their whole name.
Okay. What did you call him?
Lil Jeff.
Anything else?
Just call him a lot of names, a lot of nicknames.
Okay. What are some of the other nicknames?
Prune. It's a family nickname.
Okay.
I heard his family call him that. I called him calling him that too. On a joking, playing with him.
Anything else?
That's all I can remember.
And do you see Jeffrey Williams in the courtroom today?
Yeah.
Okay. Can you identify him by article of clothing he is wearing?
All right, it shows out. The record will reflect.
Thank you. Now, you said that you had met his family first and then you met him. Do you remember the circumstances of how you met Mr. Williams?
I can't really remember, man. You asked me to think about a long, long time ago. You know how much I've been through since then?
Here's one thing you need to do before you buy anything online. Don't spend another dime on Amazon until you watch this first. Why?
Have you been through a lot?
Tremendously.
And we're going to talk about some of those things over the course of this time together.
Yeah, I don't remember my first encounter.
Okay. What was your relationship like with Mr. Williams when you all were younger?
I mean, in any relationship, just like any other friends, you young, you just want to have fun.
What type of things did y'all do together to have fun?
One of our biggest things was listen to music, the dissect music,
What kind of music would y'all listen to?
all kinds, all genres, or however you pronounce that word.
And would you do this at your home, his home, or somewhere else?
Everywhere we go.
As your relationship developed with Mr. Williams, did your relationship with any of his family members develop?
I understand what you asking.
Sure. You and Mr. Williams have been friends since childhood. As you all continued your relationship and your friendship, did you grow your relationship with any of his other family members? His mom, his dad, any of his siblings?
Yeah.
Okay.
My mama called him son. His mama called me son.
What about his dad? Did you have a relationship with his father?
We were cool. I ain't never had my dad, so you feel me? I ain't really good with authority. But we was cool. I respected him, he respected me.
Did you ever look to his father as a father figure for you?
No.
And then what about his siblings? Did you ever develop a relationship with any of his siblings?
Yeah.
Okay. Who?
All of them.
And how many siblings does he have?
Too many to count.
Does he have a sister by the name of Dolly?
Yeah.
Okay. Did you have a relationship with a friendship with Dolly?
Yeah.
And did he have a sister named Dora?
Yeah.
Did you have a friendship or relationship with his sister Dora?
Yeah.
Okay.
Or all his siblings, not just them.
Did you and Mr. Williams ever go to school together?
I think we went to alternative school at the same time. I ain't sure.
And did the two of you ever do any recreational activity, I mean sports or anything like that? Did you play on any sports teams together or anything of that nature?
I never played sports.
What is your current relationship with Mr. Williams?
I don't have a relationship with him.
When did that relationship cease?
It never ceased. It's just I went to prison.
And while you were in prison, you did not maintain your relationship or friendship?
When you're in prison, you don't retain no relationship. All that in.
And since you got out of prison, did you not rekindle your friendship once you got out of prison?
I had more important relationships to worry about than friends. Like my kids.
Permission to approach?
As long as you've shown that to defense counsel already.
Yes, Your Honor, I believe they all have it on a PowerPoint. I'm gonna show you what's been marked as State's Exhibit 3, Charlie. Do you recognize the individuals inside of State's Exhibit 3, Charlie?
Yeah.
And how do you recognize the people in the picture?
It's me.
Is there a fair, accurate depiction of you in that picture?
Yeah.
Does it look like you?
Yeah.
Is there anyone else in that picture?
Yeah.
Okay. And does it look like that person who was in the picture?
Yeah.
Okay. Your Honor, at this time, state would like to tender State's Exhibit 3, Charlie Charlie, into evidence.
Any objections to States 3 Charlie Charlie? All right, States 3 Charlie Charlie is admitted and may be published as you see fit.
Now, looking at State's Exhibit 3, Charlie Charlie, who's in the picture?
Me.
And who else?
LaJah.
All right. And in looking at that picture, do you recall when that picture was taken?
No.
Okay. Is it before you went to prison, either in 2014 or 2015?
Yeah.
If you had a choice, would you rather pay $12 for this cheese grater on Amazon or pay less than $2 on Alibaba for the exact
From Senior 88 Atkins, can you tell if the windows to the driver's side are up or down? If you could zoom in just a little bit to the driver's side. Just a moment. Technological glitch. Okay. All right.
I can't really tell.
Okay, no problem. We'll go to another picture. If you could zoom back out just briefly, right there. Can you tell the jury what it is that you see, if anything, on the inside portion of the passenger side, front passenger's door?
I see reddish brown stains on the passenger side front door.
Okay, and in your training and experience as a crime scene technician, what do those reddish brown stains seem to be consistent with?
Consistent with blood.
Okay. All right. Now I'm going to turn your attention to the next state exhibit, which is State's Exhibit 14, Bravo Bravo, which is in front of you. Can you read that license plate tag that is there in front of you on that exhibit?
B is in boy, Z is in zebra, E is in Edward, 2206.
And what county is that vehicle registered based on the tag?
Fulton.
In what state?
Georgia.
All right. And can you tell the jury, based on the rear of the vehicle, what is the make of that car?
A Ford Escape.
Okay. All right. And thank you for the model as well. Is this the same vehicle that was noted in your report that was entered into evidence earlier as State's Exhibit 98, Bravo Bravo?
Give me 1 second.
Sure.
Hang on, missing that page.
Okay. Is it?
Yes.
Okay. All right. Thank you. Can we turn to the next exhibit? Anyone? All right. Is that a closer view of the last exhibit that we read? Just a review?
Yes.
All right. And that is, for the record, State's Exhibit 81, Bravo Bravo. Now turning to the next exhibit, State's Exhibit 93, Bravo Bravo. What is that?
It's a picture of a VIN number.
Okay. And I'm going to now turn your attention to State's Exhibit 10, Bravo Bravo. And what are we looking at here?
Another shot of the street of 1987 Fremont Street.
Okay. And do you see anything near the front passenger tire?
Yes.
Okay. And from this picture, can you tell if the driver's window is up or down?
It looks down.
And you can actually turn to that behind you if you need behind you to look at the telephone.
It looks down.
Okay.
Or it might be tinted, I don't know.
Okay, we'll go to the next exhibit, no problem. Let's turn to the next exhibit. All right, and if you, Ms. Robertson, can you tell the jury what it is that object that is near the front passenger tire?
It's a hat.
Okay, and that hat, can you tell the jury, is that one of the items that you collected and took into evidence based on your report?
It is.
Okay. All right, let's turn to the next exhibit. All right. Is this a closer view of the last exhibit? A closer view of the view that we had in the last exhibit?
Yes.
This is for the record states exhibit 16 Bravo Bravo. Do you see any reddish or brown stains on that hat?
Yes.
All right. And if you will, Senior 88 Atkins, if you can just toggle up just a little bit. I don't know if it would happen. Do you see? There we go. You can move it up just a little bit more. Thank you. Do you see any holes in the windshield?
Yes.
Okay. And what do you call, in crime scene tech language, what would you call that on the vehicle?
A defect.
All right. And what does a defect typically come, what do defects come from of this type in this photo, based on your training experience?
They come from a gun in a shooting.
Okay. And is that consistent with what you were called out for on the 12th of April, 2015?
Yes.
All right, let's turn to the next state's exhibit. All right. All right, then for the record, we are now viewing 26 Bravo Bravo. Is it fair to say that this is just a closer view of the last photograph that we reviewed?
Not the last photograph, but a close up the front of the vehicle.
Understood. Next state's exhibit.
Wow, dance. Wow,
All right. Now, based on this photo, I want to ask you: do you see any reddish or brownish stains inside the vehicle?
Yes.
All right. And based on this photograph, can you tell the jury whether or not you see any on the center console?
Yes.
And do you see any blood anywhere else in the vehicle?
On the passenger and driver's seat.
Okay. And if you would zoom out just a little bit, Senior 88 Atkins, can you tell the jury right there? Can you tell the jury whether you see that the rear windows are up or down?
Up.
All right. If we can toggle over to the left just a little bit, Senior 88 Atkins, does that window appear to be up or down?
Up.
All right. Next exhibit, please. All right, we are now viewing State's Exhibit 28 Bravo Bravo. CST Robertson, what are we looking at here?
We're looking at the reddish brown stains and the defect in the windshield.
Okay. We can now turn to the next exhibit. All right. We're now looking at State's Exhibit 29 Bravo Bravo. Ms. Robertson, is this just a closer view of the defect in the window that you described in the last exhibit?
Yes.
All right. Question did you find any, strike that. Next exhibit, please. For the record, we are now looking at State's Exhibit 9 Bravo Bravo. CST Robertson, can you tell us what we're seeing in this particular photograph?
We're looking at the overall of the driver's side of the vehicle.
Okay. And from this photo, if you can zoom in, Senior AD Atkins, just to the driver's side window, can you tell the jury whether that window appears to be up or down?
Up.
Okay, I just wanted to confirm. Now, can we turn to the next state's exhibit, please? We're now looking at state's exhibit 84, Bravo, Bravo. Ms. Robertson, what are we looking at here?
Closer up of the driver's side of the vehicle.
Is it customary to take a few of the same angles or shots of the vehicle or crime scene?
Yes.
Why might one do that?
You might get something different in the next picture that you missed in the first one.
Is
You
that
take several pictures.
Sorry, I didn't mean to interrupt you.
Go ahead.
Is that what you were possibly doing when you took multiples of each of these angles?
Yes.
All right. Next exhibit, please. We're looking at State's Exhibit 85, Bravo, Bravo. Is this just another such of the same view that we've had in the last exhibit?
Yes.
All right. Next exhibit. CST Robertson, what are we looking at here?
We're looking closer of the inside of the front of the vehicle.
Okay.
The front inside of the vehicle.
Is this coming from the passenger or the front passenger or driver's side of the vehicle?
This is from the front driver's side.
Okay. Now, can you look at the bottom of the floorboard where the driver's seat is? Do you see any glass? Okay. Do you see any glass on the inside on the floor?
No.
Any bullets?
No.
Any shell casings?
No.
Okay. Did you recover any bullets or shell casings from the crime scene within the vehicle?
1 second.
No problem.
No.
Okay. All right, next State's exhibit, please. All right, what are we looking here in State's exhibit 23, Bravo, Bravo? What are we looking at here, CST Robertson?
We're looking at a closer view of the reddish brown stains in the middle console.
Okay. Do you see any reddish brown stains on the front passenger side door?
Yes, you can see that in this view as well.
Okay. Next State's exhibit, please, Senior 88 Atkins. All right. And here in State's exhibit 24, Bravo, Bravo, what are we looking at?
Reddish brown stains in the middle.
Okay. Do you see any on the bottle that is depicted here?
Yes.
All right. When you evaluated this crime scene, did you look in the center console for anything?
Yes.
Okay. Did you find anything of value?
No.
All right. Next State's exhibit, please. Okay. Here, State's exhibit 25, Bravo, Bravo. Can you tell the jury what we have here?
A close-up of reddish brown stains.
And we're going to turn to the next State's exhibit, please. All right. CST Robinson, what angle are we looking at here of the vehicle?
We're looking at the back driver's side, the back inside of the driver's side.
Okay. Is it fair to say that this is the back rear of the driver's side?
Yes.
Okay. And do you see any reddish brown stains in this particular photograph?
Yes.
Which is constituted in State's Exhibit 86, Bravo, Bravo. And where do you see those where do you see those reddish brown stains, CST Robertson?
On the passenger seat?
Okay. Next exhibit, please.
This audiobook on Amazon has made me over $20,000, and I didn't even make it myself.
And what angle of the vehicle are we looking at here in State's Exhibit 15, Bravo, Bravo?
We're looking at the passenger side of the vehicle. Passenger front.
Sure. Do you see any reddish brown stains in this particular photograph?
Yes.
And where do you see them?
On the door and on the ground.
Okay. There you go. Do you see any inside on the floor here, the passenger side?
Yes.
Okay. And we can now turn to the next state's exhibit. State's Exhibit 82, Bravo, Bravo. Is it fair to say that this is yet another such duplicate or similar photo as the last state's exhibit?
Yes.
Okay. And do you see anything near the front passenger wheel of the vehicle?
Yes.
All right, and what might that be?
A hat.
All right, is that the same hat that you recovered, took into evidence upon responding to this crime scene?
Yes.
Okay. And we're going to turn to the next state's exhibit. Okay, State's Exhibit 83, Bravo, Bravo. Is this yet another similar photo that we just reviewed in the last State's Exhibit?
Yes.
Okay, we can turn to the next State's Exhibit. All right, here at State's Exhibit 32, Bravo, Bravo. CST Robertson, can you tell us what we're looking at here at this view?
We're looking at a closer view of the passenger side front door.
Okay, do you see those reddish brown stains that you described earlier?
With reddish brown stains.
Where do you see those stains?
On the door and on the seat and a little on the ground.
Okay. Next State's, if we can go up a little bit to the actual door. CST Robertson, can you tell this jury whether you see, or can you tell from this photo up to the passenger? There we go. Can you tell from this photo? And if not, we can go to the next one. Can you tell from this photo whether that window is up or down?
Up.
Okay. All right. Do you see now? If you can pan over to the floorboard, Senior 88 Atkins, can you see any glass in there on the floor?
No.
Do you see any shell casings on the floor?
No.
Any live ammunition?
No.
Okay. Next State's exhibit, please. We're now viewing State's Exhibit 18, Bravo, Bravo. Is this another view of the same angle that you just took in the prior State's exhibit?
Yes.
Okay. We are going to turn now to the next State's exhibit. State's Exhibit 20, Bravo, Bravo. Can you tell the jury what we see here?
Overall view of the passenger front door of reddish brown stains.
Yes, ma'am. Sorry, I apologize. Is that window up and down?
Slightly down.
Okay. All right. Let's look at the next State's exhibit. All right. Is that yet another view of the same photo?
A close-up of the reddish brown stains on the door.
Okay. CST Robertson, I'm going to transition from these exhibits, and if we can pull down that published exhibit and ask you a few more questions. CST Robertson, did you respond to, do you remember working on January the 8th, 2018? Sure. Well, hold just a second. Just a second. Do you recall?
No, I don't recall.
Would anything refresh your recollection for that?
Indeed.
What would refresh your recollection?
My report.
Okay, I have now shown defense counsel what has been a pre-marked in State's exhibit, Foxtrot 23.
23 Foxtrot. Councilors, can you all come on up for a second? Okay. recap it in a second, yeah. Okay, ladies and gentlemen, since it's almost about 12:15 and as indicated earlier, since one of your member has a appointment this afternoon, we plan on this being a short workday. So, Ms. Robertson, we're going to pick up with your testimony tomorrow. So please don't discuss your testimony with anybody except the attorneys in this case. I'm going to have you report for 12:30 tomorrow. And we'll start up at 1 o'clock and we should hopefully be complete with you tomorrow afternoon, okay?
Okay.
All right? Thank you, ma'am. I'm gonna release you at this time.
Do I bring you? Okay. Yeah. This? You can take it. Okay. My bad, my bad.
Okay. Ladies and gentlemen, of the jury, any ministerial inquiry of me? Anyone? Okay, all right. So tomorrow, consistent with our earlier directions, we're gonna go ahead and have you all report for 12:30 for anticipated 1 o'clock start time. We're gonna work some about 1 to 5 tomorrow, right? Okay. Okay, anything else of me? Okay, let me review with you your admonitions. As you leave, please leave your notepads in the basket. Go ahead and just be in mindfulness that you cannot discuss the case, anything you've heard in onesies and twosies as you go out, as you are gathering, as you're at home this evening or whatever. It would be a violation for you to discuss this. Remember, you can't also recap the testimony or recap any of the witnesses that you've heard. Of course, it would be a violation for you to listen to anything on any third-party websites, in the media, any blogs, or any place else that purports to add any additional insight to these particular proceedings. And you can only consider what's in the four walls of this courtroom that's lawfully admitted for your consideration. Remember, you cannot handicap or otherwise discuss the case while you're back there in the jury room or any other places. I have not given you instructions on how to consider the matter, and we'll do so at the appropriate time. All right, don't go by visiting the scenes. And if any third party should try and talk with you or reach out to you, that you would need to let Deputy, I should say Sergeant Ingram and myself know immediately. All right, and lastly, ladies and gentlemen, as I conclude most every time you're here, thank you for your extreme patience and thank you for the patience that you'll continue to give the parties in the process of this matter. So ladies and gentlemen, unless you have anything else with me, I'll see you all tomorrow for 12:30 and we'll get started as close to 1 o'clock as we can, okay? All right, all rise. All right, ladies and gentlemen, please be seated. Our jury has left us. All right, two things before tomorrow. Let me summarize the bench conference that was had before our jurors and our witness were released. Mr. Adams and Mr. Brown were up here at the bench, and we covered just ceasing at this point in time before Mr. Brown decided to go into another area. So that's what we covered at the bench. Mr. Adams and Mr. Brown, anything you wish to add or subtract? Okay, all right. That's the sum and substance of our bench conference. Okay, the next thing is a couple things. Please come prepared, as I mentioned earlier. If you have electronic medium, have a printed copy so we can introduce that into the record. Ms. Weaver stays very happy if you do that. Also, continue to send your electronic versions of that same evidence, because we have to have certain things as to for the assembly of our matters that have been admitted or identified into evidence. And the second thing is, please, as you send out electronic access to whatever documents or evidence you may wish to try and present, please make sure it works. And please make sure you send it more timely. Not that I'm, over 6 decades and don't appreciate having some rest, but there comes a time in the evening where I don't check emails anymore. And I suspect you all are probably in that particular category, especially if you have families and other people that you administer to. So if you could send them earlier, folks, I know that you as advocates, you have to work the task, not the time. But please go ahead as much as you can and send it as early as you can so that we don't have these problems. Because if you do have access problems, you can at least go ahead and deal with them earlier than instead of while your eyes are closed. So, all right, that's all I have. Anything else before more?
Yes, Your Honor.
Madam.
Regarding the witness that we expect will be here tomorrow, we are.
Who is?
Other than Ms. Robertson, it is also Investigator Gaither, a former retired investigator. And I called counsel for the defendant.
It's doubtful we'll get through him. We'll start maybe, but okay.
Okay, well, what I'll do, we are having the redactions that court ruled on earlier.
Yes, ma'am.
In some of the other media that we expect to introduce through her. And we will be sending that over to counsel for the defendants this afternoon. If any of them have any problems with it, I invite them to reach out to me personally and just let me know. I can and will answer my phone after a certain time. So that's all I want to do.
Okay, I'd ask that you please, excise out those things and we not make it an exercise of when they get here. I got one more thing I want to take up. So please go ahead and make sure it's complete.
And if there is any other thing that they have not listed on here that we need to look at, if they let me know before we get the redactions made, so that we are not at that point tomorrow.
Like I said, send it early so they can go ahead and look at it. Because a lot of times, you all can resolve a lot of your issues yourselves, and I'm not necessarily needed, and I don't feel offended at all. So remember, my biggest task to you all is to keep the delay time in front of this jury down to the absolute minimum. All right, anything else? Anyone?
Just, you probably remember, but I entitled it Motion in Limiting number 48, that deals with the PowerPoint the state sent us on Friday. I couldn't do it until Sunday. They cured it, but there's issues that I flagged.
Okay, but are they evidentiary issues in terms of things that I need to take up, or what?
Yes, very.
Or is it dependent upon what is testified to?
No, some things are from the internet, and it's like Mr. Wayne Carter making a statement about don't listen to the person who dresses on his album cover naked, or doesn't dress on his album cover, things of that nature. And that would be based upon the ruling yesterday. It was hearsay, statement. Over yesterday, photograph one thing, but statement another. Then Detective Dennis, I still don't have his PowerPoint at all. And then in there are videos of Mr. Williams' statements as well, which I don't believe come in, so we need your court's guidance.
Judge, those matters are not for tomorrow. Those will be later on. we won't have that witness, Dennis, tomorrow.
Okay, when we have Mr. Retired Detective Dennis? Is it her or is it him?
Dennis is a he.
Yeah, we've had him before, haven't we? Okay, all right. Have you turned over the other information Mr. Steele's talking about?
The PowerPoint was, I believe that the PowerPoint was provided in discovery, but that was in July. Right, in July 22, the first round of discovery. But I will confirm that, and if Mr. Steele has a different set of information, I'm open to him calling and we can talk about it.
Okay.
We don't have to call it slide 238, there's nothing there.
I'm sorry, slide what?
238, it's just nothing.
It
It
references the PowerPoint that was served in July of 2022.
Okay, has it been updated? Is there now a slide 238?
No, that slide was a placeholder for that particular PowerPoint.
Which is a representation or shows what?
The PowerPoint presentation served in discovery in July of 2022, constructed by Detective Dennis.
Okay, he's saying I don't think he has that yet.
He does. He's
Okay,
just
when
saying
was-
that the slide, it was served in July of 2022.
Just state, ask me.
Yes.
Just state, send an email where to find it, there's no problem. I'll look at it.
We'll make sure.
Okay, when is Detective Dennis going to testify?
It depends on when.
I ain't gonna lie, this been one of the,
Ballpark. Well, this one being.
this has been one of the smoothest trials like ever. Like just just smooth, calm, laid back.
Being who? Gaither.
So ballpark at the end of this week, since we are cut short a little bit, so either Friday of this week or next week. We only have 3 days, so
Okay.
it depends on how long everyone goes with the witness we have on the stand.
All right, well, anything that I need to take up needs to be memorialized so that I can see it, and if we need to plan for it, I can tell our jurors, we can take, we can address it accordingly.
Okay.
That's from the state as well as the defense, okay?
And the last thing, but I think you said just earlier, the better for any redaction. I'm not 100% sure what is being redacted or what's trying to be shown, so.
Well, that's why I would like Ms. Love to get that to you sooner rather than later, so that it can be, you can look at it, and if you have such concerns or objections, they can be modified by agreement, or they can be modified with the court's intervention. But I don't want to do too much of that, as I mentioned, the morning of we having the jury in place. All right. Anybody else? Okay, all right. Folks, I see you tomorrow at 12:30, okay? All right, we're in recess.
The era of DevOps has driven tremendous innovation. From CI/CD to
my mother would tell me that I have a lot of nerve if I raise those issues.
I'm so high right now, y'all. I'm about to go to sleep on y'all, man.
Stop. Just stop. I made my ruling.
Lawyers yelling at the judge yelling back, possible misconduct in front of the jury, defiant witnesses, and controversial rulings. We have some of the biggest recent moments in the RICO case against rapper Young Thug and several co-defendants as it drags on in Georgia. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. It's been a while since we've talked about the Young Thug trial out of Atlanta here on Sidebar. And if you haven't been following the case, there have been fireworks over the last few weeks that we're going to get into. So you might remember, though, that Young Thug, whose real name is Jeffrey Lamar Williams, he was indicted on a laundry list of RICO racketeering charges that accuse him of leading a criminal organization known as YSL, or Young Slime Life. And when we talk about the main underlying charge here, conspiracy to violate the RICO statute, violate the racketeering statute, there has to be an agreement to break the law, and there has to be overt steps or acts that were taken in furtherance of that agreement. That's what we mean by a conspiracy. So overt acts don't have to be crimes. They just have to be certain actions that were taken by the co-conspirators. The idea here is that Williams and others had an agreement to participate in gang activities, and there were 191 overt acts taken in furtherance of the YSL gang. That's the key there. It has to be in furtherance of the gang, not that these people committed crimes to benefit themselves as individuals, but that it was to benefit the gang, the criminal enterprise as a whole. Now, there were more than 24 other men that were charged alongside Young Thug, but that number dwindled down by the time we got to the start of trial. That was for various reasons. Their cases were severed, they took plea deals, but now we have the current defendants and we have Mr. Williams. So the defense is suggesting that YSL, though, is merely a record label and that there is no gang here, that there is no criminal activity afoot. Now, with all of that in mind, let me be clear about something. This trial has become a spectacle in my mind. I can't feel like I'm the only one that believes this, because between the courtroom packed with defendants and their attorneys, to the notoriety of Mr. Williams, to the absolute incredible amount of time this trial has taken and is going to take. Sometimes I ask myself, what is going on right now? It took almost a year just for jury selection. The trial finally started last November, but since then, we've had less than 60 days of actual court? And while it is certainly entertaining on one hand, we can't forget that these are real lives on the line here. These are very serious crimes that are being alleged. And we have real defendants, Williams and his co-defendants. They could face years in prison if they're convicted. Now, for now, I should tell you that Mr. Williams is actually locked up in the Fulton County Jail as this trial progresses. But what we want to do is we want to take you through some of the recent fiery moments from inside that courtroom, as well as some big rulings that have impacted the case. And let's start this out with a blow-up over a motion to suppress some evidence. We're talking about how Doug Weinstein, he's representing Diamante Kendrick, also known as Yak Gotti. And Weinstein wanted to suppress a 2015 police interrogation video of Kendrick because he claimed that the investigators violated his client's rights by asking him more questions after he had requested a lawyer. Now, on March 14th, the judge watched this police interview outside the presence of the jury and made a decision. Take a listen to Judge Earl Glanville.
During the course of page two, during the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk no more. That is equivocal to this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's, the appellate, case law that I've looked at, in Paldo and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, with respect to the statements that were made after that time, we do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe. It was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence, and since the state has the burden of proof.
Okay, but I've seen the video at this point in time.
Video does not encompass when the defendant actually reinitiated contact.
But the problem is he invokes, and then we don't know what goes on in the 45 minutes, but we come back afterwards, and at that point in time, you don't get to eat your cake, have your cake and eat it too. It's once he invokes, that's it. It's over.
Your Honor,
they should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about whether or not these statements were made to these set of detectives or to Galpin. I think that you all are just annoyed more so that your detective did something that he probably regrets now. And that you all probably would not have told him to do. Don't interrupt this particular investigation or this particular hearing, because what you did is you just now created a wrinkle that now I got to deal with, or whether or not the defendant has invoked his right to counsel. He has. Once you initiate your right, or
Meet Buffy. The fabric is made with.
You revoke your right to be examined, to have counsel, and to have counsel present at that point in time.
They've been doing all
the courts are very
on Young Thug, and the judge is being
cautious about reinitiation at that point in time. And you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. And that's my rule.
The thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor.
If you have other evidence independent of this, I'll consider it at the appropriate time.
And we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306 Georgia at 35, Your Honor, Edwards versus Arizona, and Your Honor, this is a 2020 Georgia Supreme Court case. And
Your Honor, at some point,
Your Honor, I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop. I was speaking. I'm sorry, I was speaking. I know, I was speaking, and I expect you allowed to speak when I'm speaking.
Both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that fact.
No, you don't. No, you don't.
Your Honor, we have just not been able to present the evidence.
No, you don't. I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
Yeah, I couldn't believe that the bailiff had to get involved in that. But look, it is an important issue. The idea of a suspect asking to speak to counsel, the questioning has to stop. So it's an interesting legal issue if his statements could come in. If he initiated the conversation once again, the judge was not persuaded by the prosecution's argument, said that once he requested that attorney, that's it. And felt law enforcement, softened him up and improperly got him to say stuff. Well, a few minutes later, Doug Weinstein, again, the attorney for Mr. Kendrick, got to have the last word for the time being. And what a word it was.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer. He invoked his right to not speak anymore. And I don't care what schmoozing Detective Thorpe did out at the Sally Port, taking my client off camera. I don't know what went on down there. I don't know what self-serving, well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order. This continued going back whenever the state loses in this case has got to stop at some point, Your Honor. Thank you.
But this certainly wasn't the only explosive moment over the last few weeks, or that the tense moments only were between Judge Glanville and the prosecution team. Oh, no. Because on March 20th, there was a moment between Judge Glanville and Williams' attorney, Brian Steele. It's hard to hear because the audio is so bad, but what ends up happening is the judge accuses Steele of kind of being unprepared and almost seems to berate him in front of the jury. Steele points out that the jury needs to be dismissed, and then he goes to the podium to address his grievance with the court.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl weeks before. There was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have
Mr.
no.
Steele,
I need to make a
Mr. Steele,
record. Your Honor, I
Mr.
need
Steele,
to
wait a
make
second.
this record.
When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating and pushing out these particular our ability to present a seamless case in front of the jury. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out the whole our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
And the court is wrong. This is the second time. And you know what it does to me? I don't care. I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay?
Forget
you
about me.
You are a grown professional advocate. I am a grown professional jurist. And people say things to me that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case, okay?
No,
but
that man's life is here.
And
you know
you're doing a fine job in representing him.
Well,
but you know what? That's just the way we are right now.
I make a motion to ask you to please recuse yourself. I know it has to be in writing within 5 days. If you want me to do that, I'll do it. And it has to go to another judge. But this is what's going on, Your Honor, whether you see it or not. You're yelling at me in front of a jury for nothing. And then you won't apologize. And I did nothing wrong ever.
I get it. You don't want the jury looking at you that way. What the court says, sometimes juries really hone in on. So if it puts Steele or Mr. Williams in a bad spot, I get it. But again, Judge Glanville denied that motion on the spot, but Mr. Steele, he wasn't done yet.
But I'm asking for a mistrial. Okay, now, Ms. Love. I don't think it's a fair forum for Mr. Williams. Okay. And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.
And the judge denied that as well. Hey, everybody. So I want to thank Morgan & Morgan for sponsoring this episode of Sidebar. Always love talking about them. Now, here is the incredible thing about Morgan & Morgan.
So you think you know Wix, but do you really? First up, we've got Shake Video Masks. You can use.
One of the reasons why I like talking about them so much.
Hey, say something about our big win.
You're not supposed to come on camera. The reason Morgan & Morgan, America's largest personal injury law firm, is so big, and I'm sure you can guess it, is because they win a lot. And don't
forget huge verdicts.
Yeah, they've won big verdicts. $6.8 million in New York, $26 million in Philadelphia. You see, the thing about them is they don't settle for lowball insurance offers from insurance companies, which is something.
Mention that you can submit a claim from your couch at home and on your phone.
And they've completely modernized the process by submitting your claim, talking to your legal team. It's all done straight from your smartphone. Again, that's something that
8 clicks or less.
8 clicks or less.
Just let him do them.
Yes. You can see if you have a case in just a few minutes.
We have 1,000 lawyers. We have over 1,000 lawyers.
All right. You know what, Dan? If you really think you can do better, maybe you should just do it yourself.
For real.
What Jesse was getting at is if you've ever been injured in an accident, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less. Start your claim. Just visit forthepeople.com/LC sidebar.
You came a little too close to me. It hurt me a little bit. I'm probably actually going to have to hire you guys now, but that was well said. That was well said. Well, we have had some very interesting witnesses in this trial, to say the least. And one of the witnesses that we've seen a lot over the past few weeks is a man named Adrian Bean. And just to give you an idea of how slow this trial has been going, the snail's pace of this trial, Bean first got on the stand on February 29th and finally finished up on March 19th. But he was actually really on the stand for, I think, 5 days. The prosecution brought Bean in to talk about a shooting that happened more than a decade ago in Atlanta. Prosecutors wanted him to establish that Williams was present at the scene of that drive-by. Bean was allegedly the getaway driver, but Bean, he wouldn't do it. No, he didn't give the prosecution what they needed. He said he was doing so many drugs in 2013 that he doesn't really remember the shooting or the car crash that happened after. That shooting is one of the prosecution's overt acts that I mentioned before. That they would tie Williams to the scene to show his participation in apparent gang activity. But going back to Bean, several times over the course of his testimony, we heard these taped interviews and phone calls after Bean was arrested following the shooting. According to retired detective David Quinn, Bean was one of the first people to even mention Williams during that investigation.
This sounds like the truth. You're the driver. You really cleared something up for me, the thug, and I got to go out here and find a picture of this joker because it's important. Because I don't think he should get away with it if he was in the car. You're not making this up. Thug was in the car. Yeah. All right. Okay. Let me.
Now I can't testify. I can't do none of that now. You know.
All right. You ain't got to testify. That's on you.
I'm gonna put me on blast front.
Well, that's not what I do. What I do is I'm trying to go slow and get all the information I need in relation to you, right? That's all I'm talking about. But the other people involved, I mean, it sounds to me like Thug got you all involved. I know you're a grown man and everything, but he came down here with an easy way to make money, it sounds like. And it went, who knew the police were going to be there?
So much for not having to testify. But when prosecutor Adrian Love tried to question her witness, this pretty much sums up what happened.
My statement is that I don't remember anything from 2013, man.
Despite that, in a win for the state, prosecutors were able to get these recorded interviews and written transcripts introduced into the record. So even if Bean doesn't remember, they have it on tape and the jury hears it. Okay, so was Bean's testimony helpful for the defense? It's an interesting question because in January of 2023, Mr. Williams' attorney, Brian Steele, he sat down with Bean, recorded their conversation, and in that interview, Bean says Young Thug was not there, said the police were the ones who wanted to connect the rapper to the crime.
I'm interested in Jeffrey
Crazy.
Williams.
Look at that.
Young Thug.
Look at that shit.
Was he in, around, a participant
When
in
he
the
gonna get out?
direction,
Young Thug is
anything
gonna get
involved
out.
in
Right.
that event that we're
I mean,
talking
he
about?
ain't going. He got.
Turkey Red, September
He's gonna get below down. We don't know.
2013.
We already right.
Like I explained, you know,
We did too much
when
last
you know
time.
all that occurred, everything took place.
The
You
cap.
know, they was, you know, trying to force him in on something that he wasn't even in. Like I said, I'm not gonna lie on the brother. You know what I mean? And, you know, he wasn't with us. Young Thug was not in the car with us that day. I don't even know how his name really got mentioned. Maybe it was a lot of hype through the streets. Or, you know, I might have was in company talking and said his name, but I ain't, you know what I mean, him and then saying that he was with us. You know what I'm saying?
And when you say that they wanted him involved in the case or whatever your words were, who is they?
Detectives and other, you know, people that was inquiring, you know what I'm saying? I don't know, discuss the neighborhood or whatever.
The police?
Yeah, police.
The authorities or whatever, the prosecutors, the police?
Yes, sir.
Okay.
Now saying he was kind of forced by authorities to give them Young Thug, but it wasn't true. Adrian Bean, look, just doesn't seem like the most reliable witness. He says one thing here, another thing there, then tells the prosecutor he actually doesn't remember anything from that time. And during some of his testimony, Bean lashed out, questioned why he was even in the courtroom.
All this going on right here on this, got me up on this stand, talking about this and that third, all this extra stuff that's going on, Your Honor. Am I on trial, Your Honor?
Sir, you just have to answer the questions, unfortunately, at this point in time, okay? That's all I can tell you.
Am I on trial?
No, sir, you're not on trial. But you have been properly summoned here as a witness, and you're subject to examination until I release you.
I never consent to do none of this, sir. I ain't signed nothing. My name ain't on nothing. They come get me. They y'all don't threaten to lock me up. Hey, I got a family too.
And after all this time on the witness stand, it seemed like Bean was pretty much fed up with being there. I mean, just listen to what he said right in the middle of questioning toward the end of his testimony.
You just heard that you explained that you qualified it as the detectives and police. And I asked you the authorities, the police, the prosecutors, I just made it broad, that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all, man. I ain't gonna tell you no lie.
He's so high right now, he is about to pass out. I have covered trials for a while now, and I can tell you right now, uncategorically,
never saw
can't say I've heard a witness say that one on the stand. No, that is amazing, to say the least. Amazing. All right, let's move on to another witness who was actually not shown on camera, only identified as AB. In fact, this person didn't come to court at first, defied a subpoena that she says she never received. So this witness was allegedly the victim of an armed robbery back in 2013, reportedly involving Mr. Williams, which is apparently not in the indictment. But Prosecutor Love told Judge Glanville that she has spoken with the witness several times about the court needing to hear her testimony and said that the witness indicated she did not want to come to court. So she ended up telling Love that she was in the hospital, couldn't come in, but the DA's office says that officers found her at home, actually arrested her on a material witness warrant. But if the prosecution expected her to be particularly cooperative once she was on the stand or to give some bombshell, incriminating testimony against the defense, they were wrong.
Learned after asking that it was a friend of your child's father, known to you as Thug, who was at the door.
If you're not making $158,000 per year, but you'd like to, I strongly...
No. Do you recall telling the police that you opened the door and let Thug inside your home?
No.
Did you ever say to the police that Thug's brother was also with him?
No.
And do you recall telling the police that you turned your back on Thug's brother, and a person you called DK after letting them in your home?
No.
Do you recall telling the police that you turned your back on them to walk into the kitchen to make your baby a bottle?
No.
Do you recall telling the police that when you went to the kitchen, Thug's brother put a silver 9mm to the back of your head?
No. And my baby didn't even drink bottles. My baby was breastfed. So no.
Did you tell the police that the two suspects, along that Thug, his brother, and DK demanded money from you and your gun?
No.
Not a lot to say there. Well, the following day, AB was cross-examined by Keith Adams. This is another member of Williams' defense team. Listen to this bombshell that was dropped.
You were asked some questions by the assistant district attorney, Ms. Love. Is that right?
Yes.
You remember her asking you at one point, are you afraid of Jeffrey Williams? You remember that question?
Yes.
And then she may not have said Jeffrey Williams. She may have said, are you afraid of Thug? You remember that?
Yes.
Okay. And your answer was no. Is that right?
Yes.
You have no reason and had no reason to be afraid of Jeffrey Williams. Is that right?
No, I don't.
Okay. In fact, when you testified yesterday, you were on edge. Is that fair to say?
Yes.
You didn't want to be here.
Yes.
And part of it is because of the interactions, and your reaction yesterday was based on the interactions you had had, not with Mr. Williams or anyone over here, but with the district attorney's office. Isn't that true?
Yes.
You told us when you were back there that they had been, quote, harassing you for a number of months. Is that true?
Yes.
And in fact, you said that prior to coming out and testifying, that the only person you were afraid of, you didn't want to be around, was Investigator Hamilton from the district attorney's office. Is that true?
Yes.
Mr. Hamilton had contacted you prior to yesterday. Is that right?
Yes.
Mr. Hamilton had harassed you. Is that correct?
Yes.
In fact, you told us when you were back there that you didn't want to come out and see him because he had sexually harassed you. True?
Yes.
You felt like, and you told us, that you were really concerned about coming out here.
I'm going to object as to relevance.
I'm going to hold objection.
You told us
That judge solid.
the times when he would contact you,
Been
it
solid.
seemed like he was trying to date you.
Yes.
He wanted to meet you.
Fair. Fair.
Supposedly to talk about the case.
Yes.
But you didn't feel comfortable going to meet him by yourself.
Nope.
Because you didn't feel comfortable going to meet him by yourself, you brought your 20-year-old son with you.
Yes.
Was that before or after you met with Mr. Hamilton and he told you, don't talk to nobody else?
That was after. He told me before that. I came in, I seen Miss Love, and that's when I told y'all yesterday that me and Miss Love, we only discussed for a brief because they was like trying to tip me.
Quite the revelation, right? Well, AB was back on the stand again a few days later and explained more about her accusations against Investigator Hamilton as the defense showed text messages on a large screen.
Now, how about the next one? That same night, Wednesday, February 7th, 6:45 p.m., where he says, hit me up if you're bored later. We're not going to talk shop. Remember that text message?
You text an investigator?
Did you talk to him later on?
Texting that?
Yes.
Did y'all talk shop?
Yes.
What do you want to talk about?
Going out.
Going out? Going out as in walking out the door or going out on a date?
I think.
And this is February 7th of 2024, this year, when the investigator for the DA's office is supposed to be talking to you about a case. But in fact, is calling you, talking to you about going out on a date. Is that true?
Yeah.
Dog, look at your thumb. You looking like, dog, that's funny.
The fact that this
They fucked
employee of
over.
the district attorney's office
The thug-
was trying to date you,
the thug out. The deep
come into your mind
itself
as
over
you're thinking
this
about
whole
whether
game.
you have to come in here and testify or not.
Yes.
This is really not a great look for the
What?
Fulton County District Attorney's Office, to
That's
say the
all
least.
bad.
But the drama did not end there. No.
They
Another
lying
big
for the
witness in this
pussy
case,
on
called by the state, was Walter Murphy. And
Now
he took the
the fucking
stand on
attorney
April
trying to
10th. And to give you a little bit idea of
smash
who we're talking about. So
the women.
Murphy, also known as DK, he took a plea deal in which he entered a guilty plea to a charge of conspiracy to commit RICO, and he would be required to testify in this trial. Another important witness for the prosecution, right? Murphy, childhood friends with Williams, who he knew as Lil Jeff, but he says after he got sent to prison, he and Williams didn't reconnect.
What is your current relationship with Mr. Williams?
I don't have a relationship with him.
When did that relationship cease?
It never ceased. It's just I went to prison.
And while you were in prison, you did not maintain your relationship or friendship?
When you in prison, you don't retain no relationship. All that in.
And since you got out of prison, did you not rekindle your friendship when you got out of prison?
I had more important relationships to worry about than friends. Like my kids.
Prosecution asked Murphy about some of his tweets from 2012 that included terms used by gangs, including the tendency to change the letter C to the letter B in words to show support for the Bloods gang. Murphy testified he did a lot of things like this when he was just young and dumb.
And I want to go down to August 25th, 2012. Can you read that tweet on August 25th, 2012?
That's a song.
What does it say?
It's been a long time coming, baby. I just called to see how you been doing lately.
Now, you just said it's been a long time coming. Is there a B or a C there for coming?
To be.
Okay. Why would you tweet it as a B?
It's just what I was doing right there. I did a lot of stuff without meaning or purpose.
If you've been getting scam texts like these, it was me. I said that probably means your data's been leaked, and I have all of it.
I was childish, young, dumb.
Again, not really giving the prosecution what they needed.
Yeah,
what did prosecutors do? Well, they walked Murphy through his plea deal and what he admitted in those documents. Murphy is allegedly a co-founder of YSL, which he formed around 2012.
Oh.
Did you ever create a group called YSL?
A group, yeah.
Okay. Was it something else besides a group?
Not to my means of knowledge.
And what does number 1 say?
YSL, otherwise known as Young Slime Life, began as a neighborhood group but evolved into a gang.
Okay. And did you initial number 1?
Yeah.
Those are your initials, right?
Yeah.
Okay. So when I just asked you, was YSL a gang? Why did you tell me you don't know? Did you not acknowledge that in this document?
Yeah, but it say evolve. I don't know when it evolved into a gang. I know when we made it, it was a neighborhood group. It was a group of guys from the neighborhood. I made it a music group.
And in this acknowledgement that you initialed, you said it evolved into a gang. That's what you initialed.
Yeah.
Okay. So YSL,
I don't know when it evolved into a gang though.
I didn't ask you when. I just asked you, did YSL become a gang?
Yeah.
All right.
And that would happen a lot, him being confronted with statements he made to law enforcement or the state versus what he's saying or maybe not saying on the stand about what he knows regarding YSL, Young Thug, and others. He was on the stand under direct examination for a couple of days, cross-examined by the defense attorneys. That started on Friday with more cross expected on Monday. And that brings us to something that we know you're all thinking. Is this trial ever going to end? It is a fair question to ask. Well, the defense attorneys, they're certainly worried about the pace and the sheer number of witnesses left to go. So far, they've made it through the testimony of about 40 witnesses.
We are losing our jurors. We are losing our jurors. I look over there at them and they are trying their best. They are trying their hardest. Often they are taking notes, but other times they have just tuned out.
In fact, Doug Weinstein, who represents co-defendant Diamante Kendrick, I mentioned it before, filed a motion back in March to put a limit on the number of witnesses that will be called. Well, Judge Euro Glanville is none too happy with the pace of this trial and even suggested he might have a remedy that not everybody would be excited about.
I have spoken with our sheriff, and consistent with court, if necessary need be, we'll start having court on Saturday and Sunday. Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up, I think we need to work a little harder in terms of being able to streamline, and that goes to both sides. And look, I don't want to work that way too, because it's me and my staff and my team and the sheriff and his team and everything else. But we will do it because we're going to have to recap some days. I don't want to be in 2027 trying this case. Or as Mr. Steele said, I want to be here next Super Bowl trying this case. I have power of contempt. I don't want to use that. I don't. But it's come down. We've been in trial a long time. I think I've been very clear with everybody about my expectations, which serve you all and your ability as advocates in this case to try the best case you have.
The judge ordered the prosecution to provide him with an updated witness list, which seems now to have been whittled down to 150. But to be fair about that, that's down from around 700 at the start of this trial. Just remember that. That's just the prosecution's case, by the way. Not even who the 6 defendants want to call.
I do have some concerns about 120 days of trial time. That's going to take almost 4 months. And, I'll remind the state, you told me, or Ms. Hilton told me, it's going to take about 6 months. At this rate, it's going to be 12 months. And that doesn't include anything that the defense may choose to. I'm concerned about your case, Chief, at this point in time. The defense will present whatever they wish to do with, and I'll deal with it. We'll deal with it accordingly. But,
we were trying to be finished by June, frankly, as I told the court earlier.
Yes.
We can't control cross-examination, and that has extended our estimation of the time that we've set.
Well, like I said, if you disclose things, if you don't disclose everything, and we don't disclose things timely, then what I'm doing is I'm taking up more time. What I want to do is I don't want us to take up 2-3 hours. I can't do that anymore. So I'm telling you, you need to make very sure that you've disclosed the evidence and you'll be able to tell me what day you did, because if you can't, I'm gonna exclude it. That's my remedy at this point in time.
We will see, of course, if the court is able to keep things on track, but between late starts, early dismissals, long comfort breaks, days spent arguing motions, vacation time, and more, we really could be talking about a case that is really years, takes years. And I feel really, really bad for that jury, to say the least. But of course, here on Sidebar, we will bring you all of the latest updates. Thank you so much for joining us, everybody. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time. He was reportedly spotted at a Topgolf in Miami with his teenage daughters. Seems to be pretty relaxed for a guy who
shit ain't overnight, that's a whole lot of flips. This shit ain't overnight, took a whole lot of trips. This shit ain't overnight, gotta learn and get your grip. This shit ain't come overnight, it just look like this. This shit ain't overnight, been through so much shit in my life. The game colder than ice, that blade sharp cut you like a knife. Always had my own low fame, let a nigga feed me with a slice. We was grinding all night just to make them turnovers precise. I had to sacrifice, I had to cut some ties, minimize. I had to realize, I use my real eyes, see through the lies. Club going live, strange guys, say FBI. Notify the guys, I swear they had the nerve, think I was high. This shit ain't overnight, that's a whole lot of flips. This shit ain't overnight, took a whole lot of trips. This shit ain't overnight, gotta learn and get your grip. This shit ain't come overnight, it just look like this. Blood, sweat, and tears, I lost peers to face my fears. Learn to protect my grip, living on the edge so many years. When you living life in a fast lane, gotta know when to shift the gears. Gotta decode everything I hear in my ears, so severe. This shit ain't overnight, that's a whole lot of flips. This shit ain't overnight, took a whole lot of trips. This shit ain't overnight, gotta learn and get your grip. This shit ain't come overnight, it just look like this.